All right, sir, you Gabriel Cruz?
Yes, ma'am.
And we've got cause numbers 26 DCCR 0373. Mr. Cruz is charged with stalking. Cause number 26 DCCR 0374, charged with violating a protective order. And then cause number 26 DCCR 1060, charged with violating a protective order. And the state has filed a motion asking that I increase the defendant's bond. Hold on, I need to see what the bonds are in each case.
I believe they're $100,000
In all three cases?
Well, individual $100,000 in each individual.
300,000 total.
That's
Yes.
what I need to know.
Yeah.
All right. And has not made bond in any of those. Is that correct? Or he
He
has?
made bond in the first two, and then he picked up the last new case, and he's in jail on that case. He has not bonded out on that charge.
And the last offense, it looks like, has that same offense date. It was just indicted on, at least on my docket. Let me look at that.
No, it's a different offense state. It's my understanding.
Let me look. Oh, okay. Well, so offense date. It's not, okay. It's not. So the offense date in that last one is March 1st of 2026.
That's right.
So 2 weeks or so after the first alleged offense of violating a protective order. Mr. Coleman, you may proceed.
Yeah, I filed a written motion. I have no doubt the court's reviewed it. I'll just hit the highlights, if I may, Judge. The criminal history, I just would ask that the court reevaluate the bonds in light of this defendant's criminal history that includes a conspiracy to possess or distribute cocaine out of the federal court, 2010, unlawful carrying a weapon, Jefferson County, 1994, possession of controlled substance, 1998, an adjudication for possession of marijuana, state jail amount of marijuana, 1998, and a arrest for an aggravated assault that was ultimately dismissed. I think it's still probative in this setting, that history. And in addition to the criminal history, Judge, I'd ask that the court consider the fact that this defendant allegedly committed this new offense of violation of protective order while out on bond for violation of protective order, and it involved the same victim, Judge. I think there are a lot of concerning issues here related to public safety and the safety of the victim in this case. I submit to the court that $100,000 bond on each of these cases is insufficient. I'm proposing a bond of $250,000 in this case.
Yeah.
I'd ask the court consider this.
I'm printing a couple of PCs as well. Give me just a second. I'm gonna get some stuff printed out so I can take a look at that. The PC in both of the in all of the cases. So
Oh, yeah, you did.
great.
No.
Y'all stop talking.
Sorry.
Was there one more that printed or not? Is that right? It's Okay, I see. So the one of the stalking and protective order is the same.
Day.
He said.
That's right.
Mr. Parker?
Your Honor, I would like to point out that this is, he and his wife are going through a divorce and it's been nasty. Part of part of the communication or contact with her was because she wanted him to see the child and told him to come get the child. And that's why I was there. I think I can't just, and give me judge, I haven't talked to him after he bonded out, so I don't have a whole lot of information. And I just received a new case, so I'm not familiar with all the facts of the new case. I'm limited to what I know. But my communication with him is that he's been contacted by her, and I'm sure she was admonished by Judge Freeze or whoever that to not contact him. But he did say that was one of the reasons she has contacted him to see his child, and then she tries to use that against him, and which is common. We see this a lot of times when there's a divorce going on, and they want to use anything they can. But we're asking that. I mean, he's on there's third-degree felonies, and $100,000 is a high bond. He had some help on the first two cases. I'm not sure if he's going to be able to have that help on these cases, but we're asking to leave the bond the same, $100,000 on with other restrictions. I think is appropriate for these types of cases. If he was out and was intended to hurt her, he could have hurt her. I think even the facts that Mr. Coleman has raised and some of the stuff is that if he was around her, he could have hurt her if he wanted to. But I think it aligns with what he is telling us, that he was, even though he shouldn't have gone over there to see his child, that's more than likely what happened. So we're asking to keep the bond the same, Judge, with other monitoring restrictions.
Killed myself, silly. What not? Killed myself.
Right, so Mr. Cruz, if you have a protective order against you, I know what those say, and I know what the judges and the magistrates tell you about that. No one can give you permission to violate that protective order. And if you guys were just talking about a visitation of your child, I wouldn't have a probable cause that has an allegation that there was 96 text messages, 47 emails, 9 voicemails left stating that you don't care what the protective order says and that you're going to do what you want to do. In addition to pulling in the driveway, that's on February 23rd. 2 weeks later, same thing, numerous calls, and the officers locate you in your vehicle a block away from the house driving past. So it obviously, regardless of whether you have already done anything to hurt her, my job is to make sure that that doesn't happen. And I feel like you have completely disregarded the protective order that was placed on you and the rules that were placed on you down in another court. And so at this time, I'm going to grant the state's motion. I'm going to raise the bond in cause number 26, DCCR 1060, which is the last offense date of March 1st of 2026. I'm going to raise that bond to $250,000. Condition of that bond, if you make it, is that you wear a GPS monitoring device at all times and that you would be on house arrest as well. So you would not be allowed to leave your house. I am going to modify the conditions of your bond in the two other cases that you've already made bonds on. Additional bond.
This is the turning point of the hearing. Legally, bond conditions are designed to balance a defendant's right to pretrial release with the court's responsibility to protect the community and any alleged victims. What makes this moment significant is that the judge is focusing not only on the original allegations, but also on conduct that allegedly occurred while the defendant was already subject to court restrictions. The court points to repeated communications, alleged contact attempts, and behavior that appears inconsistent with the purpose of protective order. Emotionally, you can hear the frustration in the courtroom as the discussion shifts.
Bond conditions in those two cases, which is 26 DCCR 0373 and 0374, are that you have a GPS monitoring device on at all times and that you are on house arrest. You're not allowed to leave your house without my permission. All right, you can go back with the bailiff. We'll set your case for an announcement.
The bond amount stayed the same in that one?
Yes, I didn't
Okay.
change those bonds amount. I raised the last one
Okay.
and made those modifications.
Okay. I did. Hey, I actually. Hey.
Sir, you're live in Stratton.
Yes, ma'am.
And this is 19-33601. Mr. Stratton is charged with capital murder. And what's the announcement?
Judge, we have gotten, I think, all of the media, but we're having a wrinkle with one of the police reports that's rather lengthy that Ms. Molfino is trying to figure out why it's not transferring over from the old program.
Okay. Other than that, though, everything has
Other
been.
than that, I'm missing about 20 or 30 pages of police report. Other than that, I think we're good.
And what we're doing, Judge, is somewhat equivalent to kind of a reverse manual Bates stamp, if that makes any sense. With it converting from workflow to Odyssey, there was all kind of glitches, including the media. We have recreated that from originals at the police department. But maybe that some of it is merged into one another, but myself and intern are going through it this time and just documenting every single page number so I can get that to Mr. Rappert and he can tell me which 20 he's missing, because just I'm missing 20 out of the 2 red wells I had. It was difficult, and I wanted to, of course, have everything, but I think we've probably exhausted all of our discussions regarding the judge and are headed to the trial docket.
So is there any reason to believe that those pages out of that police report would change the position?
I don't know, but I doubt it, but I don't know.
So here's what I want to do. I'm going to give one more reset for an announcement.
Okay.
If the case is going to trial, I want to try it before the end of the year. So we're getting already halfway through the year. So we need to start looking at some dates and what's available if possible for the end of
I'd
the
like
year.
to get a special setting judge. I have some out-of-state witnesses that.
Yeah, no, it's going to definitely be, I think because it's the nature of it and we'll definitely make sure that when it's set, it will be the case to go. We'll do a protection order if you need it and
Yeah.
things like that. So we'll make sure everybody's available. If you have any other cases that are set that are going, that are specially set, kind of maybe start an email with me, you guys, and we can start coming up with a date. Obviously, if something happens before then and it's taken care of, that's one thing. But if we want to start looking for a date, let's go ahead and start looking for that now.
I guess we can, after we get the next reset, we can have a pretrial conference in chambers and get some dates.
Yeah, I mean, just start an email
Okay.
and we'll start it that way. And
Because I have so many family members, I will reach out to them now and kind of take a look. If obviously with the age of it and the witnesses, et cetera, it's a lot of moving parts.
it is a lot. So that's why we need to get it set so that everybody can get everybody here and subpoenaed, and we don't, we can't. It's going to be difficult for everybody to be completely available, but if they know ahead of time and they're under subpoena, then they won't have a choice.
Do
So
have
I'd rather do it that
I
way.
do have a trip planned out of the country.
This hearing featured several very different cases, but each one centered on accountability and the consequences of decisions made while under legal scrutiny. The most significant ruling came when the judge increased the bond in one of the stalking and protective order cases, while also imposing GPS monitoring and house arrest conditions. The court emphasized that protective orders exist to prevent future harm and violations, especially repeated allegations involving the same individual, are treated seriously. The hearing also highlighted other major criminal matters, including a capital murder case preparing for trial.
Out of the country for Thanksgiving.
You'll just make sure you have that
I'll send that to him.
vacation letter
I
in.
will. I'll follow.
Okay. All right. So let's just do 30 days. That way you guys can please get the police report. If that changes anything, we'll know then. Otherwise, between now and then, let's start looking at other dates, but we'll have one more announcement
Yes, ma'am.
before trial.
May I be
Okay.
excused?
Yes. Good morning. Are you Andrew Howard?
Yes, ma'am.